Good afternoon. Welcome to the MyHR's monthly webinar. Today's topic is covering a really important topic, I think, and one that's quite a high profile one of late. Really looking at family and domestic violence, and in particular, family and domestic violence leave. So this has rightly become a high profile issue over the last few years, with a lot of media attention, a lot of, workplaces having interventions and initiatives to work towards making, Australia a better and a safer place for everyone. And this sort of very much touches on that. So, we feel that, the topic of family and domestic violence leave is something that's, really important. And so we've decided to run two webinars on it. Today's one is very much an information session covering, a bit of a history of the sort of current state of play, a couple of attempts to address this concern in the past, as well as current initiatives that are in place. But yeah, very much, provision of information with the expectation that there will be some changes. Of course, everyone would be aware of the election of the Albanese government earlier this year. And so this initiative around paid family and domestic violence leave very much comes off the back of that. And yeah, it's widely expected. The initiative's been introduced into Parliament, and it's widely expected that it will pass both houses this year, and will come into effect next year. So, like I said, we've decided to run a bit of a session on this today. The session will cover the recently introduced legislation that will give all employees 10 days of paid family and domestic violence leave. What the implications of this change will mean largely for small and medium-sized businesses, how small and medium-sized businesses can prepare for the change, which will roll out from February 2023. So before we jump into it, I should probably introduce myself for those who don't know me. My name is Julian Hackenberg. I work for MyHR Australia in the capacity of sort of head of advisory in Australia. I have about a decade's worth of experience in HR and in employment and workplace relations, largely advising small and medium-sized businesses. But yeah, currently advising MyHR's client base, which is made up of companies of sort of various shapes and sizes, and various industries and the like as well. And I'm joined today by my colleague Robert Minkus. Robert, maybe you can introduce yourself as well.
Yeah, well, Julian, I've had a couple of decades more experience in some larger industrial blue collar organisations, and the issue we're talking about today has been, sitting around there for that entire period of working in that employee relations space, and that's whether it is a large organisation or a small organisation. There are some really, I suppose, difficult matters that you've got to grapple with when you're faced with dealing with a family and domestic violence situation at work.
Yeah, totally. Thanks, Robert. And look, in terms of today's session, just to make everyone aware, it is being recorded, and is likely to be. Robert, we've just had a comment come through that some people are struggling to hear you.
Okay, how's that?
Yeah, that sounds a bit better to me. We'll keep cracking on, and we'll see if there's any further comments around that as we go. But yeah, so just so everyone's aware, today's session is being recorded. The recording will be available afterwards on various websites, including MyHR's website. So in turn, any questions will be recorded and available afterwards. So if you do have questions, we do have a Q&A at the end. But if you do have any questions, please only share details that you're comfortable in sharing. yeah, and as I mentioned, there's a bit of a Q&A at the end of the session. You can also submit questions as we've already received as we go through as well. So thank you. So if we go through our slides, I mean, this is really what we're going to be covering in today's session. Really looking at the sort of current leave obligations for employers when it comes to family and domestic violence leave. Then we'll be looking at a bit of the history of change, and particularly the Fair Work Commission test case decision from May 2022. From there, we will run through in some detail the proposed Fair Work Act changes to family and domestic violence leave, which we believe will come into effect from 2023 onwards, looking at the definition of what family and domestic violence leave is, and look at some particular examples, particularly around casual employees. One of the big elements of this is the introduction for this paid leave entitlement to apply to casual employees, which is quite unique. And as I mentioned, we'll have a Q&A at the end of the session. So, I mean, many employers in Australia do deal with these sorts of issues and have queries come up from time to time. And it's common that we want to understand where we can seek assistance and help. But yeah, businesses can direct employees affected by family and domestic violence to a number of organisations that can help, including 1-800-RESPECT and the National Domestic Violence Hotline. So that's good information to have as well. But if we crack on and yeah, take a look at the current state of affairs. Robert, family and domestic violence leave currently exists in the National Employment Standards. Can you start by just giving us a bit of a summary of that entitlement?
Yeah, well, obviously at the moment, and Kim, if you can let me know whether you can hear me, that'd be awesome. Just in case that there's a problem with that audio. But look, the main thing to note about the current entitlement is that it's unpaid, and it applies to everyone that works for any employer anywhere. So it could be, when they're executive general manager, right down to just a casual award employee coming in sporadically, and that isn't much of a problem because the current entitlement is unpaid leave, which doesn't accumulate and can get taken in periods of 1 or more days, or in a block of 5 days. And that entitlement is available on commencement of employment and thereafter after the operational, the anniversary date of employment operating for that individual. So it drops on that anniversary date, Julian.
Yeah, amazing, mate. We're getting mixed reviews of the audio. Kim's given us a thumbs up. She's saying it's better. Yeah. James reckons he still can't hear you that well. So we do apologise because I can hear you, Robert. So perhaps it's a volume issue. It is a little bit soft there at this end, but I can hear you, but it is a little bit faint. But yeah, like I said, Kim's given us some thumbs up to tell us that it's a little bit better. So, awesome.
All right.
So yeah, so we'll keep going. All right, mate. So anything further to add around the existing entitlement for?
Well, I think the most important thing to keep in mind is that entitlement, when it first was introduced into those awards back in 2019, they actually didn't do much other than replicate what was in the Act. So the principal bit of law, the Fair Work Act 2009, changed. When it came to changing all those industrial awards that cover all those award employees, the Fair Work Commission decided we're just going to say whatever applies in the Act applies in the award. And the only other caveat they added was that there needed to be some sensitivity about the information shared when dealing with these matters, that is, keeping it confidential. And they also talked about some of the evidence that was required by an employer when it needed substantiation. So that would relate to police, court, violent support service documentation. So that was about it.
Yeah, right. Okay. No, that's good. That's good. And so, yeah, so we're talking, and so therefore we've sort of got to the point of the Fair Work Commission test case decision, family and domestic violence leave in May 2022. And so, yeah, so you sort of set out a bit of a summary there of, you know, in terms of it applying to award covered employees and the like.
Yeah.
Cool. And so that's paid at the base rate of pay, you know, full-time and part-time employees. So casuals were excluded from that, importantly as well. Okay. All right. And so that brings us to the Fair Work Act National Employment Standards changes. So 5 days of unpaid leave to become 10 days of paid leave. And so, mate, so we're looking at the introduction of that to be 1st of February 2022. But then for February 2023, and then August 2023 for small businesses. You know, what are the sort of main differences? If you know, I noticed you got a few highlighted points here in the slide.
Yeah.
If you just sort of just cover off the main sort of differences that we'd really want to emphasise for small and medium sized businesses.
Well, I think the most important thing is that the entitlement comes in a drop of 10 days at the commencement of employment and then on anniversary date. So it's not accrued progressively, which is what was proposed under the Fair Work Commission's decision back in May 2022. As you've already noticed, it's going to apply to casual employees. Now that's a real, you know, difficult matter, because casual employees by nature are casual. They're employed on a daily basis or an hourly basis, and you don't really have the opportunity to understand what is 5 days for them in a lot of instances. But you know, in some instances, you've got employees who work regular shifts. You know, they're either there on 4 days a week, for example, 5 to 6 hours a day to meet an operational peak. Or they, you know, you might have people there who are actually casuals, but in that role in a de facto probationary period, I suppose, is what some employers are doing with that casual period of employment. Not ideal, but that does happen. And I suppose in those instances when it does happen, well, the regularity of the employee's hours is real easy to determine. It gets a bit random though when you've got a casual that is more picked up for work on an as needs basis. So there's no set roster for them. So that's where the trick lies with, I think, with the casuals, the management of that, and just understanding which point you're at on that process to figure it out. It's the full rate of pay. You know, they obviously pay the full rate of pay, and it covers all employees. So, you know, the Fair Work Commission's decision back in May 2022 only extended to those people covered by modern awards, but this thing is going to cover everyone because it's a part of the National Employee Standards, which is a minimum entitlement that applies to everyone. You're someone on the minimum wage or whether the CEO of BHP.
Yeah, beautiful. Thanks for that. And just for anyone who doesn't quite, I mean, that definition of full rate of pay, I think it comes from the Fair Work Act. For anyone who doesn't understand that definition, really, it means that the employee would be paid, you know, effectively whatever they would have been paid had they worked that shift. So, for example, if they were eligible for a shift loading or penalty rate or something for having worked the shift, then that's what they would be entitled to be paid for family and domestic violence leave.
Only thing I might add is that if there was an allowance which was reimbursement, for example, reimbursement for an overtime meal allowance, that's obviously an expense not incurred. So, those sorts of allowance wouldn't apply in that instance.
All right, excellent. Thank you. And yeah, mate. So we've got some definitions here on screen. So, so as well, this is an expanded definition of family and domestic violence. Yeah.
And what it's done is extended the conduct, which you can see is either what reads violent, threatening, abusive behaviour, but includes not only to a family of member or a relative, but also a household member. And that household member or that family member, if they are in seeking to coerce or control the employee and cause them harm or fear, well, that is effectively the definition of family and domestic violence. Okay.
No, okay, yeah, excellent. And so that's an extension of the coverage previously.
Exactly, yeah. I think you find it similar to what happens in personal carers leave. So if a member of your household is sick, there is an entitlement to claim personal carers leave in some instances there too.
Yep. Okay, and we do have some statistics on screen around, obviously the extent for which, domestic violence is a real scourge in our society. There's obviously been some, discussion around cost to business and, versus, I think this being a really positive thing for where Australia's headed. I think overall there seems to be a lot of support for the introduction of the, of the extension of paid domestic violence and family and domestic violence leave. I mean, do you have any thoughts on that around, where this is sort of landed in terms of a balance?
Yeah, well, I think if you look at the next slide, Julian, where we've got those stats up in detail. We've got the first thing I think we can observe is that is more frequent than I would expect. Now, I know this is going on, but when I saw those stats, statistics, my view was, wow, that is a far more frequent events than what you would expect. And of course, those statistics are then manifested by specific conduct. I think the next slide covers that off too, Julian. It shows there's examples of assault, abusive behaviour, stalking, depriving liberty, derogatory taunts, damaging, destroying property, including animals, unreasonable withholding of support, and just isolating people. So these are all the examples of family and domestic violence that translate into anxiety disorders and other psychological concerns that then happen and are associated with this. And as an employer, if an employer presents with these conditions, under our work health and safety laws, of course, we've got to be mindful of that.
Yeah, definitely. We just had a question come up from Andrea, and just wanting to confirm, if a part-time employee who works 3 days a week, for example, takes 2 days off as family and domestic violence leave, they would only be using 6 of the 10 as family and domestic violence leave and still have 4 days paid entitlement as a balance.
No, it's not prorated, it's 10. So it's where the shift falls, Andrea. So my reading of it is that if you're a part-timer, you're not getting a pro rata entitlement, you have got 10 days. And that is available to you. Yeah.
That's
similar, and that's exactly the same as the 5 days unpaid. The fact that it's unpaid, of course, helps from a payroll point of view, but the concept of the entitlement 5 days is consistent. In this instance, there's a 10-day entitlement for those part-timers, and that 10 days is applicable to them as well on a paid basis.
Yeah, and I suppose it would have to be structured that way to enable the coverage of casual employees as well.
So I think in the example Andrea mentioned, the question was the part-timer took how many days, Julian?
So they work 3 days a week, takes 2 days.
Well, they've got another 8 days.
Okay, again, we've got some definitions up on screen. So a close relative of an employee includes, child, parent, grandparent, grandchild or sibling, of a spouse or a de facto partner, relative as per Aboriginal Torres Strait Islander kinship rules apply. Reference to a spouse de facto partner includes former spouse de facto partner as well, importantly. And likewise, a member of an employee's household includes any person living in the same residence as the employee, such as extended family members or a housemate, whether related to the employee or not. Okay, so a couple of other particulars around family and domestic violence leave. As we've pointed out here, so days will not accumulate from year to year. How about notice and evidence? I know that's a big, just talking to some of our clients around the introduction of this, that's a big, concern. I think they're mostly supportive of the introduction of this sort of thing, but are just concerned that, people might milk it or whatever else. So what are the sort of requirements around notice and evidence?
Yeah, well, in terms of evidence, it's pretty much the same as it was under the unpaid regime. So it's, if you need it, you've got, and your required documents, it's police, court, violence support services, statutory declarations. Of course, all that information needs to be treated confidentially. In terms of the notice, now that is a case by case, I think. So if the employee can reasonably notify you for an absence of shift, and you have got a procedure there that requires the employee to notify, before the start of shift or 24 hours before or as soon as possible, then that is the notice requirement. To take the leave and then front up the next day, well, I suppose claiming the leave, I suppose you just got to really look at the circumstances and consider or not whether the request is for the purpose asked for. So, that's the rule with anything, actually. So you will have a procedure there. If people follow that notification procedure, the expectation is they should follow that notification procedure. And if they can't, well, there could be exceptional circumstances. And I suppose you need to consider those exceptional circumstances and make a decision once you've heard it, listened to it, understood it, and made a conclusion. Yeah.
Okay, so we've got a couple of examples. So maybe if I can sort of just read through, and then Robert, you can talk to some of these. Just on the matter of proof, I suppose we had a question. So what are the proof of evidence can employers ask for?
Well, it would be any document from a competent authority. So if, for example, the police are involved and there is some documentation the police have issued, that could be looked at. If there are any court proceedings or court orders or requirements to attend court, that documentation from the courts could also be relied on. Statutory declarations is a fallback. It of course gives you then detail you can follow up on if you need to question it. And then of course there is the usual documentation from, I suppose, a doctor, if that's if things are that bad and it involves that, or the family community service provider that's providing some assistance. Now, that might be in relation to reorganising some safe accommodation or meeting to advise a way to, work the way out of the situation.
Yeah. So it's a bit broader than, say, something like personal carers leave, where it's sort of generally a doctor, in some instances maybe a pharmacist or something like that. It's sort of, dependent on the circumstances, and I suppose it's sort of broad ranging in terms of, what may lead to the employee taking an absence based on family and domestic violence leave. So the evidence may come from a broader range of sources as a result.
Absolutely. Yeah.
Okay. So if we run through maybe this first example, so we've got an employer usually calls every Monday morning to offer shifts for the week. So Monday, the employer calls and offers shifts on Wednesday, Thursday, and Friday. The employee is available to work Wednesday, Thursday, but unsure about Friday. This is a casual employee, of course. So agree on Wednesday and Thursday, and the employer will wait to hear about Friday. So they've agreed on shifts for the week. On Tuesday, the employee experiences family and domestic violence. For the week, they're unable to work and they're doing things to deal with the family and domestic violence. Now, the employee is entitled to take paid family and domestic violence leave at the full rate of pay for the hours agreed on Wednesday and Thursday, as they were not rostered to work on Friday, but could choose to take a day of paid family and domestic violence on Friday. So just talk to us about that last one. So
yeah, I know. Well, that's that all depends on how you communicate your work requirement for the week going forward. So in this instance, this is what I would call a more normal pattern of work for a casual employee, where on a regular basis they're rostered to work. Well, in this instance, I think what this example covers, and I've got to say to you, this is actually out of the second reading speech. It's an example table to help the legislators understand what the intent of this was. So what it's saying there is there has been a tentative agreement to work Wednesday, Thursday, and Friday. Now, bearing in mind, the Friday was up in the air and it was at the employee's discretion. So in that example, which doesn't translate in this PowerPoint slide, the employer wants the employee to work Wednesday, Thursday, Friday. The employee's up in the air about the Friday, and the ball's in the employee's court to determine whether they want to work the Friday. And it's for that reason that Friday then can become a leave day, an FTV leave day,
right,
because of the way that communication was organised and the work was organised.
Yeah, right. Okay, so because it's sort of it's been offered and the employee's considering it, and that's sort of generally the nature with which they determine whether or not shifts are worked or not, then it would fall within scope. Okay. All right. And then the second example, we've got a full-time employee commenced on the 5th of March 2022. The 8th of February 2024, the employee experiences family and domestic violence. To respond, they need to find new accommodation, amongst other things. And so 7 family and domestic violence leave days taken over 3 weeks. The 5th of March 2024, the entitlement resets to 10 days because it's their anniversary date. The employee takes a further 8 days over 8 months to access various services. Criminal trial on April 2025, 4 days taken. The full 10-day leave entitlement reset on the 5th of March 2025. Over 15 months, the employee takes 21 days of family domestic violence leave days. Okay, so this is really just sort of articulating the point around, that sort of reset date is really something to be mindful of for employers, because it does impact on. It does seem. It can sort of seem like they're using more than their full set of entitlements, but it's just the nature with which how the entitlement works is you get your full allocation, from day one, and then that's sort of reset from your anniversary date the following year.
Yeah, well, I think the point to take away is it's the perception. So been there for 15 months, taking 21 days. How could that be?
Yeah.
Well, the reasons for that is the date of commencement or anniversary date was early in that 15-month period. Had it been July or November of 2022, the entitlement would have shrunk by 10 days because the anniversary date would not have clicked over. Yeah, that's I think the story there just shows you how it's just 10 days that drops, bang, it's there to be used all at once or used sparingly and as time circumstance dictates. Yeah.
All right, excellent. And we've had a question just about the casual situation. If the casual employee refused outright in that case to work the Friday,
wouldn't have been entitled to the Friday. It was organised. It was so before the working week started, it was agreed. No, I'm only working Wednesday and Thursday this week. So
yeah.
that's the week is set based on that conversation.
Okay.
I'm sorry. Yeah.
All right, cool. All right, so this is where we're sort of talking about how businesses can sort of prepare themselves for the introduction of family and domestic violence leave. So what are we talking here in terms of a couple of approaches?
Yeah, well, I think the thing to keep in mind is that this creates and turns this 10 days. I think you're just going to let's stop thinking about the reasons for it, and let's start looking at this as 10 days of a paid leave entitlement. And like any paid leave entitlement, of course, you've got to have the proper controls, and you've got to understand what you can do to properly manage it. The worst thing you want to do is having, for the wrong reasons, people accessing themselves to this leave without having a process there to be able to vet it, understand it, and approve it. So that, I suppose, is point number one. So that's pretty straightforward. The other thing I think that needs to be understood is that when this thing happens in the workplace, you do get some work performance and possibly absenteeism issues. And I suppose before you start jumping down the disciplinary route, not that it's the first question you ask when you ask, well, why are you away, or why is your work performance bad? But you need to be mindful that this is now a circumstance that the industrial regulatory framework has got a perspective on, and it contemplates. So you gotta be mindful when you're talking to people about these performance issues that if this comes up, you need to be able to vet it, respond to it, and consider it accordingly. And then I suppose the other aspect of this, and this is a risk that's always been there, these last 2 points, if someone's not on their game and at work, well, they're potentially a risk at work. So it's probably important to understand that, not only from just a keeping them safe point of view, Julian, but when you get down into that workers' compensation premium part of the process, there's an issue about, is this a work-related injury? So, having a proper process there to understand what's going on, rather than just dumping it into workers' compensation, which, is sometimes an easy thing to do, is just a management practice which is going to just add to your premiums, where you've got where your premiums are sensitive to claims. So not many of our members would have that sort of problem, but a number would. So you just got to be mindful of the fact that that's an additional cost that needs to be identified.
So it's a matter of factoring it into your employment costs and how you deal with things like absenteeism and performance and even work health safety and workers' comp. as well.
I think it's more important that it's almost like a separate line. It's a separate event, and if you don't see it, you're not going to control it, and you're not going to understand it. So it's going to blend into something else. So it's having a focus on the thing. I think is the important thing to remember, and that'll help you obviously manage the leave, and also make sure it's doing what it's supposed to be doing.
Okay. All right. And then of course there are other costs that, which sort of go to things like absenteeism, like employees being unable to get to work in the first place, injuries sustained, appointments and that sort of thing, which occur in work time, which, I think having the leave entitlement is part of the idea there, is that it allows them to be a bit more proactive with dealing with these sorts of things. Whereas, if they don't have a paid leave entitlement, it sort of creates this sort of in-between situation where these things can really just play out over periods of time and go unresolved, and then have potentially greater impact on the individual as well as the workplace.
Yeah, absolutely. Yeah, and there's that whole business reputational thing and image, and just all the other adverse effects associated with it. And I suppose, if you look at what has happened in the last 5 years, this whole phenomena has had a focus, in quite an extraordinary way. I mean, I've got a teenage boy, and the stuff I'm hearing in the car and around the dinner table just about the respect sort of issues just gets you to understand that this is a lot more than an isolated workplace problem. There's a focus on this from the community, which is driving the change. So, from a reputational point of view, having some sort of process to deal with these sorts of things, I think, is almost incumbent on you. And you've had a range of other, high-profile events happening that have ended tragically. You've had Australians of the Year being nominated to these who have stood up and helped with process. So from a business context point of view, this is probably something business needs to get their mind around, because the whole community, the government, the work health and safety authorities, everyone's got to focus on it. So, we're going to have a focus on it as well.
Yeah. All right. So we've got a few recommendations here around best practice. So I think what we're advising our members, or we will be when it's formally passed, is to really have a policy around dealing with this sort of thing. And so I think, Robert, our sort of main inclusions there is sort of, firstly is offering support to the employee, allowing the required time off, making them aware of the entitlement, as well as advising or alerting the employee to how they can seek help, how the business can help them in accessing that help as well. But, being flexible. Anything else that you wanted to add in relation to that?
Well, I think again, it's just it's a real messy sort of situation. Historically, everyone just doesn't want to know about it, or hasn't wanted to know about it, and they've done that because it is such a personal, private matter, and in many times, the person that is subject to this sort of conduct is so ashamed and so embarrassed about their circumstance. So they're not wanting to talk to you about it. And I can think of a number of circumstances where you've had, women who have been casuals. They've been working, afternoon and night shifts, and a bit odd for a working mum, but that's all right, because you need the labour to work there. And then one day, you find out that the person has to go to hospital. And, you think, oh, all right, well, there's an accident at work, what's happened? And then, of course, you get the word that, no, it wasn't an accident at work. They just need to go to hospital. And the discussion with the employee ensues, and the employee goes, well, really, I don't want to go to hospital, because if I go to the hospital, the police have to get involved, and that's something I don't want to do. So you've got yourself in a situation where the person needs medical help, and you send them off to the nearest medical centre and sort them out. Not too worried about the money. You're just absolutely aware of what's going on, and you want to support that person. Particularly in the instances I've dealt with, they have been fine workers. Bit of a problem with absenteeism every now and then, but by and large, just a decent worker. So you find yourself in these circumstances where, say, a couple of weeks down the track, you get the word again through your team leader predominantly, because that's where the relationship is. The person is just saying, look, I've organised myself, and if I could just get a week's pay, I can get out of this. And sure enough, companies I've worked for go, sure, have your week's pay. They either disappear to their family or relatives to a safe place, wherever that may be, or it might be more local. And in the circumstances we've had, those casuals have come back in a better frame of mind. They've been engaged as a permanent employee. And you talk to them and they just say, yeah, geez, if I'd known you would have done this, I probably would have done this a year ago. And I can tell you, Julian, that's when you drop through the fall. And I think that specific issue is what this is all about. The legislation's there so everyone knows the support's there. There are organisations out there that can help individuals. It's not up to the employer to help the individual. They're not trained or qualified, but there are support organisations there. And the connection with those people then gives the individual the opportunity to make a plan. And that's where the support comes in, and that's where the 10 days comes in. Now, I've got to tell you, in those circumstances, it wasn't 10 days, it was up to 10 days, but it was enough time to help them out. And in the circumstances where the employees returned, geez, they were awesome employees. There was such a pleasure and a privilege to think you'd be able to assist in a process like that. So I think in terms of a policy and procedure, it's provide the support where you can, but more particularly get the individual to get the professional advice from those organisations. Respect 1800 and the domestic national violence. That's really the aim of the policy. Give them the support, give them the encouragement. When they get in touch with these organisations and come up with a plan, because that's the thing, there's got to be a plan here. That's when you step in again as an employer to help. Yeah, that's
yeah, amazing. We've got those details on screen again. But look, that pretty much covers what we wanted to run through with today's session. I'm mindful that we've covered a fair bit of content. We've had a few questions pop up throughout as well. But if anyone's got any questions or anything that sort of immediately comes to mind, that I'm just looking through the Q&A and the chat now, and it looks like there's not really anything coming through. Of course, those scenarios sort of prompted a few points of discussion. But yeah, look, just sort of last chance, if anyone's got any questions, feel free to shoot them through now. Otherwise, you can always get in contact with us, and we can assist you with any questions that you might have. I think beyond that, we might wrap it up there, Robert.
Yep.
Just got a bit of information on screen about MyHR and who we are. But thank you everyone for joining today. It's been a good session, and like I said, one which we were pretty keen to provide some information on. But yeah, if anyone requires any further information, get in touch. We'll also be having a second part to this, sort of expanding a little bit more on what employers can do to prepare. Likely to be next month, but further information will be distributed about that as well. So thanks everyone for attending.